All right, so let's get to the crux of the matter. It's about everybody holding on to a piece of legislation and looking at what to obey and what not to obey. There are two laws, by the way. The Local Government Administration Law, number 5 of 2018, which allows the governor to set up caretaker committee at the end of their tenure, and then within 3 months organize an election. That's 90 days. There's another law that was amended by the Amewule-led House, Local Government Administration Law, number 4 of 2024, that in the case of war or failure to organize an election, the tenure of the local government chairman can extend to another 6 months, and it can continue like that, but not beyond 6 months per time. And that is what the 21 local government chairmen are holding on to. The other 2 are holding on to 28. So there's a lot of legalese in between all of this. There's even a Court of Appeal hearing bill for tomorrow. We're going to look at all of this. We're being joined on the program by 2 legal practitioners. Chukuma Chinwo, a legal practitioner, he joins us via Zoom. Mr. Chukuma, thank you so much for coming on the program, as well as Achinike William Wobodo, who is a legal practitioner and a public policy analyst. Mr. Wobodo, thank you so much for coming on the program.
Thank you for having me.
Let me start with you, Mr. Wobodo. My assumption is that you know all the facts around this issue. But just a simple, straight question, as I posited before. The 21 local government chairmen are saying that they are abiding by the Amewule-led amendment of that law of 2018, whilst the other 2 are saying we will obey the law as far as, because they even took the other parties to court, and the court actually said, Justice Q actually said, look, based on a breach to Section 9.2 of the Section 9.1 of the Local Government Administration Law of 2018, number 5 of Rivers State, as well as the 1999 Constitution as amended, there's no such thing as tenure elongation and all of these things they are talking about. What do you make of this situation before we get deeper into the conversation?
Well, first and foremost, I'd like to say that there's a misconception about what the Amewule-led House of Assembly did. It was not a tenure elongation as they would have made the public to know. What the Assembly did was to make provision for a situation where there is no election, where the Rivers State Independent Electoral Commission is unable to conduct election. And this amendment is in tandem, and it also complies with the provisions of Section 64, Section 105, Section 135, and Section 180. All of these provisions are made by the Constitution in the event that the election is unable to hold, to replace members of the National Assembly, members of the State House of Assembly, the office of the President, and the Governor. Now, what the Local Government Amendment Law has done is to borrow a leaf from these provisions that I have cited to say that if for any reason the Federation is at war and the physical body of Rivers State is involved, or for any other reasons, the Rivers State electoral body is unable to conduct election, the Rivers State House of Assembly, by a resolution, shall extend the tenure of office by the equivalent of their term, but not exceeding 6 months per piece. The sections that I've read out to you now, the sections that I've cited, Section 64, Section 64, Section 105, Section 105, yes, 180 and 135, all make the same provision. Now, the only difference is that for the Constitution, the National Assembly contemplated that the only time when election may not hold is when the Federation is at war. But in the case of a state, these assemblymen have contemplated that a state of war may not be the only time when election may not be held. For instance, if a governor who is responsible for fails to do so, or he fails to release funds to the electoral body, election may not also hold. So in such circumstance, the Assembly thought it wise that for a situation like that, the Assembly should pass a resolution for the democratically elected persons to continue. The essence of which is to enforce the principle of Section 7, subsection 1, which says that in the system, every council shall be elected based on democratically agreed principle. That's what the Assembly has done.
Let's not take it to Mr. Chinwo. Mr. Chinwo, of course, there are two parts to it. In fact, there are too many tools. There are two laws and there are two issues. One is the issue of the legalese, the law. The other issue is the issue of the status of the lawmakers, which is one of the greatest bone of contention, because that will give effect to whether which law will be obeyed or not. So I want you to respond to, if you don't mind, to what Mr. Nwobodo said, given the perspective he's brought to the conversation.
Thank you very much. It's always very important to look at, when you're considering a law, you look at the background, and I think you really hit the nail on the head. I read an article written by my another friend, Nwobodo, this morning, and I followed this argument, so I think I didn't even know it was appearing in this program. I think that it's important to look at the legislative history of any law. This law, the local government law, administration law of 2018, was a law that was, proposed by the executive and, of course, passed by the House of Assembly. And it's made very clear how Rivers State wants its local government system to run. Now, the National Assembly provisions he referred to, Section 180 and all that, they're talking about situations of war. So if you want to extrapolate it, you're going to ask, is there war in the states? And then this law they are making, is it a law amendment? Is it that of the states who proposed it before? And then what is the background? Everybody knows the background of Rivers State since October last year, that the state has been in a situation of this engineered crisis. And so you make a law that is just intended to cause division, contrary to the provision, the fundamental provision of separation of powers in the system. That's why the law they made is creating problems of solving problems. And if you make a law that's like that, you end up having crisis in the states. But unfortunately, there is no war. Just like your correspondent saw at the Board Council, there is peace in the states. And then people have accepted the situation that the tenure of the former chairman has expired, and then new caretaker committee or interim management, as the governor called it, have been set up. So I don't understand where the House of Assembly made that law. But in any case, like you rightly pointed out too, Justice Kyo had made a judgment saying that law is null and void. And for all that we know as lawyers, until the Court of Appeal, which we expect to see tomorrow, approves it, overrules it, or decides contrary, that is the position of the law. And so the law as it is today is that the 2018 electoral local government law is what is operating. And that's what we should abide by. And that's the situation I see. And that's how they add to Archie's opinion.
So you say there is no war, and this is what I find quite interesting. When, yes, we've seen visuals, but we also know what's happening. The police have reported 2 security operatives killed. And I mean, if people are killed, then obviously points to the presence of violence. We saw the effigy of the bust of a former governor being pulled down and the words that were being said. You could see the demeanor of people, and I'm sure you've seen videos, gunshots, people running helter-skelter. So yes, I know that it's important to put out the right messaging out there so things, we don't see breakdown of law, but it's also important to speak to the reality on ground. So in the light of these facts, 2 people dying, the images and videos that we've seen and the words we've heard, yes, you don't want war, but how do you deal with this current war situation?
Well, unfortunately, that's what happens when people resist peaceful change. JF Kennedy said, those who make a peaceful change impossible make violence reaction about violent change inevitable. Quite unfortunately, you may have seen before now the videos trending of Ikwere local government, Chidi Lloyd. Incidentally, all of them are Ikwere local governments, and of course the nearby element threatening war and fire, and somebody saying you will stand with your forefathers and all that. That's just the reason why you're seeing this. But the people are saying, your tenure has expired, you get out of the place and let the government be set up properly. And that hasn't happened. If you ask me why didn't the election hold, everybody knows the House of Assembly has made itself an anti-state as assembly. And unfortunately again, they have now left the House, the party, and leaving the party where there's no crisis. The Section 109 1G is clear. There are no more members of the House.
Pardon me, Mr. Nwobodo. I mean, that point is quite important, yes, and it's been at the heart of this. But regarding the governor's pronouncement yesterday as well, I'd like to get your thoughts on it. So the other side has been asking, what law did he rely upon to ask the local government chairman, the outgone one, to hand over to the administrators in the local government? They've been asking that, in which of the laws is this contained in? Would you like to provide some?
If you make an amendment to a law or repeal a law and the court nullifies that repealing, it means that the old law is standing. That's just simple as that. They repealed a 2018 law and the court has nullified that repeal. So that is why it goes back to the other law. There's a law existing and you come in and say, take it away, and because you have no power, you have no right to do it. And so it returns to the legal status quo. Is that status quo is the law that was in existence. So the governor relied on the 2018 law. That was a law proposed and made by
Mr. Chinwo.
When he was governor here.
But Mr. Chinwo.
So there's no conflict there's no issue about which law. It's clear the law that they use, the governor relied upon, is 2018 law. But
Mr. Chinwo, your conclusion may be hasty there, because even in the 2018 law, it says here in section 9, I believe, subsection 4, that the governor shall swear in the newly elected chairman, a local government council, after the completion of the tenure of administration. So the governor hasn't sworn in any chairman, but he has gone ahead to announce that heads of administrations should take over the local governments. And we're looking for that in the existing law, but there is no provision for that.
The provision you cited is what will happen in normal situation where elections have been conducted, where everything has gone up. But you see, we have a situation where no election has been conducted for reasons we all know. And because no election has been conducted, is the local government going to be left to those whose tenure, democratic tenure, had expired, who don't have the mandate of the people anymore? No. Who is there? The head of administration of the local government are there to manage the resource or to oversee and coordinate the resources of the local government until further action is taken. And the governor has also said, in the interim, I have an interim management committee for the local government. So that situation where election have been conducted, definitely the governor will swear in the elected people. But where is the election? That's the question you ask. That is where I actually refer to this article. If you talk about doctrine of necessity, that you respond to the situation based on the necessity of the time. And I think that's why the governor have taken the steps he took.
Okay, let's suspend the scrutiny of the laws now and look briefly at the politics. I'd like to come to you, Mr. Nwobodo, by asking what the intention of all of these is concerned, particularly particularly the amendment of the local government law of 2018 by the Martin Amewule-led State Assembly. Some would ask if it is to hand over the structure of the local governments in River State to FCT Minister Nyesom Wike, and former governor of the state. I ask this because some are saying, is there a new political party in River State named PDAPC? Because there are reports about the convergence, in certain places of political meetings comprising both APC members and PDP members. Is this true? And what are your thoughts on this?
Well, first and foremost, I do not think that what is playing out at the National Assembly, the conflict between the legislature and the executive, has anything to do with the internal conflict or the disagreement between the Honorable Minister of the FCT and the Governor of Rivers State. I'm not aware of any meeting of joint meeting between members of the APC and PDP. So speaking on that will amount to speculation. Now, but what I think is critical is the intention of the House of Assembly to further deepen democracy within our local government system. This should be a concern by everybody in Nigeria, both in Rivers State and beyond. I didn't quite hear what Mr. Chinwo said, but let us even look at the laws, the Section 9. You can take them one after the other and evaluate them in line with the local government, with the Constitution of the Federal Republic of Nigeria. And you will find out that the amendment the Assembly members made are consistent with the Constitution of the Federal Republic of Nigeria. Section 1, subsection 2 of that section is where they brought in the eventuality of an election not being conducted. Section 2, subsection 3 is where they brought in the issue of the period for the conduct of election. In the previous local government law, it says election shall be conducted within 3 months after the local government tenure has expired. That is not democratic. The amendment that we are talking about here says election shall be conducted before the expiration of the tenure of a local government, which is consistent with what we have in our Constitution in Section 76, Section 116, Section 132, and Section 178 of the Constitution. All provides that election must take place before the expiration of the current term. And if you also look at subsection 4, the subsection 4 talks about who shall swear in the local government chairman. As a matter of fact, the governor has no business in swearing in a local government chairman. It is not the president that swears in himself or the president that swears in the governor. It is the judiciary, the Chief Justice of the Federation swears in the president, and the Chief Judge or the Grand Cadi, as the case may be, swears in a governor. But the amendment the local government has made, in any case, has also accommodated the governor, and it says the governor shall swear in. But where the governor is unable to swear in or refuses to swear in the local government chairman, the assembly did not say they will swear in. They said they will pass a resolution for judicial officer or the magistrate to swear in. What is unconstitutional about that? What is inconsistent with the Constitution about that?
All right, Mr. Amobodo,
these are the issues that we should interrogate, not whether the Honorable Minister is at loggerhead with the former governor or the present governor.
Mr. Amobodo, I'm familiar with the provisions of the laws that you're citing, and at face value, it looks very brilliant. The only cloud around it is the fact that a lot of people have seen politics being interplayed, because 2018 law has been there until this feud. Some people are wondering if there was not this feud, whether an amendment would have even taken place whether there would have been an amendment in the first place. Because if you look at the resolution brokered by the president, the last item on that resolution has to do with dissolution of local government, which is where politicians used to control their political structure. But I don't want us to talk politics. I want us to talk the law. Let's talk about the other aspect, which will either give effect or otherwise to the amendment of that law based on what happens at the appeal tomorrow. But there is something that happened when they reached out to the Court of Appeal. Justice Charles Wale had given an ex parte of interlocutory injunction saying that Martins Amewula and the others should restrain themselves from parading themselves as lawmakers, given the fact that they defected. Now, which
court, please? Which court, please?
Justice Charles Wale of the River State High Court.
Okay.
Now that has been appealed by the Amewula group, and there were 11 prayers. Out of the 11 prayers, 5 were granted, one of which is a stay of proceeding, perhaps looking at issues of jurisdiction and all of that. The other ones were not vacated. The court said it would be premature to make any decision now. Let's hear and determine the case. But for the time being, let's maintain status quo, which is my question. When it comes to status quo, especially if it has to do with status quo antebellum, it looks like everybody has their own interpretation, like offside rule in football. In your understanding of the law, given the background that I posited, what is status quo?
Status quo antebellum is the state of affairs before the party approached the court.
In context, I know what status quo antebellum is. I'm not asking for that definition. I gave you context for what I'm asking. Because one party is claiming the status quo is Oko Jumbo, should hold on to the reins of power. The status quo is Amewule is still the Speaker of the House. Given what the ruling is, if you've seen the CTC, the 35-page CTC, if you have access to it, what is status quo based on the understanding of the Lord Justices?
The status quo is the status quo before the parties went to the High Court. The Court of Appeal is not a court of first instance. The Court of Appeal is a supervisory court. The Court of Appeal continues the proceedings of a lower court. The proceedings of the Court of Appeal is not independent of the High Court. What the Court of Appeal is doing is exercising a right of review of the High Court. So when the Court of Appeal says maintain status quo ante bellum, it's actually talking about the status quo of the parties before the hostility commenced. The party is not the status quo before they went to the Court of Appeal. It's the status quo before the hostility commenced.
All right.
The Court of Appeal, yes. All
right, Mr. Hobo, I don't want to, I just added antebellum to it, but the statement that was used in the CTC was status quo. Let me take it back to Mr. Chinwo. Mr. Chinwo, your interpretation of status quo relating to the issue that is subject to appeal. We don't want to talk about the determination so that we don't fall contempt.
Thank you very much. It's important to interpret the statement of the decision of court in the context in which they were made. The Court of Appeal said the present status quo. And when the court granted the 7 orders, the orders that they granted, these were entirely procedural for the, as they will call it, the Court of Appeal, housekeeping processes. The issues that were decided by Justice Charles Wale, all of them, because they let it remain there until we hear the parties. So where we are today on the law is as at the judgment or decision of, the ruling of Charles Wale at the time he made that order against which they appealed. And the Court of Appeal said, we are not looking to that until all your papers are in. When we state on the 20th, now that must also understand, it doesn't mean that judgment will be given that day or not, but they will hear the appeals, whatever motions, everything taken. So it is important we get that very clear. The court did not say status quo ante bellum. It said the present status quo. It's like somebody is running from a particular point and he has run 10 kilometers or 10 meters or whatever, and then somebody runs to court to say, please stop running. And he stops there because, okay, let the present status quo. It is no more, court was very careful about it. It's no more the status quo before he came to court. The status quo before he came to Court of Appeal. And that's what is there. We all know what status quo ante bellum is. We all know what it is. But when the court is specific, like it did in this case, very specific, it's so that it will not be misinterpreted. Where you have confusion is where court said, let the status quo remain, that people are going to interpret. But this one, the court was very clear that it is status quo at present, the present status quo. So that was the judgment of the High Court. And that's, I think, that's what is governing the situation now.
Okay.
It is telling what will happen when the Court of Appeal sits and when it decides that there will be any change or affirmation of it.
So does that mean, so let's trickle it down further so we don't speak over the heads of people. That status quo to you, the interpretation and what the court is trying to say, does that mean that the Martins Amewule group are no longer members of the State Assembly, or they are, but Martins Amewule is not the Speaker, or they are not in APC, they are still in PDP, or that there's even no issue at all? What does that status quo mean to you?
Now, that matter has not been decided fully in Charles Wale. He made only interim order and an interlocutory order, which has been appealed against. So the decision whether they are validly in the House or not, whether they have the right to remain in the House or not, has not been decided upon. What is there at the Court of Appeal is that they appealed against the ruling of the Court of Appeal. If they had waited and the whole matter was maybe expeditiously hard, they could not have appealed against the top matter. So you see, there's still layers of going back and forth that will happen. So what it means is that the High Court has not said APC or PDP or whatever, but the High Court said from the evidence presented before me, it means you cannot present yourself as a member of the House.
Okay.
So that is why, this process, people should be patient maybe and ask for accelerated hearing. If God gives us accelerated hearing, it is easier to handle everything together at the Court of Appeal.
All right.
Otherwise, you're creating a situation where you go back and forth. Okay. That's the situation now.
Right, so I want people to understand better.
God will not on his own decide that these people did not defect or they have defected. It will only give a decision and ask the lower court, either the same judge or another judge, to hear the matter and determine it.
So let me take this to Mr. William Wobodo. I mean, we head to the courts to provide clarity, to resolve conflict. But it looks like what we're seeing now is people have approached the court and they've come back with even more conflict. Maybe it's the making of legal practitioners, and I've had people say time and again that we need to speak with lawyers in this country. So, Mr. William Wobodo, do you agree with his status quo? Is that your own status quo? And I think this is just a classic example of what people have said, that maybe we need to have a sit-down, a judicial sit-down in the country. But Mr. William Wobodo, to you now.
Okay, so let's again put this matter in context. The first question is, when you're talking about what did the group go to court to challenge? They went to court to challenge the membership of Martins Amewule and Co. But the question is, at what time was this law passed? The law had been passed, Martins Amewule. So when you are applying the principle of status quo, are you also applying the principle of status quo to a law that has already been passed? That is the first point. The second point, as he has agreed, is that no court in Rivers State, Justice Wale has not decided on the membership of Martins Amewule and Co. But on the contrary, there's a judgment of the Federal High Court by Justice Omotosho which recognized Martins Amewule, a final judgment which recognized Martins Amewule and Co. as judgment has not been set aside. They are not talking about that judgment, rather they are talking about an interlocutory injunction that has been appealed against. An interlocutory injunction from a court that the Constitution expressly does not vest jurisdiction upon.
Right.
Now, when you talk about the lawyers and how they interpret status quo, the meaning of status quo is clear.
Right.
Like he has said, if the Court of Appeal has said maintain present status quo, the present status quo would be the present status quo at the time they went to Court of Appeal. Now, the law, which is the reason for the confusion, the law has been passed. It's not as if when the Court of Appeal said maintain status quo, Martins Amewule and Co. went back to amend the Constitution contrary to the directive of the Court of Appeal. This law was already in existence.
Right, so I need to quickly come in because of time. We need to manage time. And I think we can go on and on with this status quo debate. But I want to ask a question of conscience here today.
Yes.
What would you say to those who have said that the judiciary across board, from the courts to the practitioners, are at the heart of this crisis, unnecessarily exacerbating it? What would you say to those people? Because they look at the lawyers and they say, well, the lawyers are meant to provide the right counsel, and say, well, yes, I know that this is my job, but I think you're wrong here, and let us step this down. They look to the court too and say, well, they expect the judges to carry themselves in a certain way and give those pronouncements by law. So this is a question of conscience. What do you have to say to it?
Well, I do not think that judiciary is completely the problem. I also think that the implementation of the law and how the lawyers present the cases before they get to the point where the judges interpret the matter is also a principal factor to be considered. For instance, it is the lawyers that will want to delay the matter. It is a lawyer who knows that a particular court has no jurisdiction to entertain a matter, and then yet he goes to that court because he thinks that he can forum shop and get judgment quickly. He thinks that if he goes to the appropriate court, he may not get favorable judgment or an interim order to stall a situation. So he knows that the court does not have jurisdiction, yet he goes to that court. You don't blame the judge who decides to hear the matter, because he has a duty to hear the matter. And until his jurisdiction is determined one way or the other, he will continue to make out those interlocutory orders that put us in the situations that we are. So I don't think holistically that the judiciary has set out to mismanage the situation in Rivers State. No, I don't.
Interesting, you know, different parties giving different interpretations to the many different court rulings. But I'd like you to react to this, Mr. Nwobodo. The Rivers State House of Assembly will this morning, according to reports, begin the screening of chairmen and members of caretaker committees of the 23 local government areas. Now, I wonder what interpretation you'll be giving to this within the context of the 2018 law and the law amended by the Martin Amewule-led Assembly.
Now, that is the situation that we have found ourselves. The same people who are saying that the Court of Appeal has said maintain status quo is the same people who have admitted that the High Court has not delivered judgment. In other words, the High Court has not proscribed Martin Amewule. Is the same persons who, in the face of those interlocutory orders, the orders of the Court of Appeal, are still going ahead to amend, to screen candidates. In the first place, there is an amendment of the 2018 law, which, though has been set aside, is subject of an appeal. The rest is before the Court of Appeal. Lawyers are trained to obey the rest. Parties are trained to obey the rest. But you see, they will not. They want to foist a state of hopelessness on the court.
Oh dear, it seems we have lost connection audio through to Mr. Nwobodo. Let's go to Mr. Chinwo now to react to perhaps what Mr. Nwobodo has said so far about the screening of caretaker committee chairman. Mr. Chinwo, over to you now.
Well, that is the existing House of Assembly. Just like Nwobodo said, that's where we have found ourselves. If like what happened to Zambia national team in 1993, if all the members die, or most of them died, it doesn't mean they don't have a team again. You have to reconstitute. People have the existing speaker have written to INEC, please conduct an election. INEC hasn't responded. People have written to INEC, conduct an election. PDP have done so. Now, what happens is that, are we going to say that the Assembly will not operate at all? With the governor run as a sole administrator, when there are still members and duly elected members of the House in existence? So that is the situation. Who constitute those who say there are no more members of the party elected? Those who breach the constitution and taking themselves out has left the state where we have three. No, we are all not happy. I mean, Martin Amewule is of my constituency, the same ward with me, and I will wish he's in the House. Well, and everybody in the 27 local government, wards of Rivers State, all that, we wish their members were in the House to participate, but the people have abdicated. So the three that are there are conducting this, and that's where we find ourselves. We'll have to make do with that and hope that INEC will wake up to this responsibility, or the judicial process will go through fast enough so that Rivers State can be restored to where it ought to be. Under Amechi, we had costs should be shut down. Under Wike, we had some other crises. He was able to manage the situation. But now we have legislature being shut down, or because his own followers have abdicated. It is not happening in Rivers State. Our own democracy is being retarded. Our separation of power is not what it ought to be. Rule of law, therefore, is suffering. We must all get to the situation where these things have to be rectified. But as long as some individual interests want to put themselves above the state, they are going to have situations like this. And people are going to identify to one position or the other. And I think that's what is happening. It's unfortunate. There's no way anybody will like it. Like I said, what it means today is that the screening is being done, my constituency is not represented. And there's no one can be happy about that. But what do? We have to abide by that until the situation is rectified. And that's what all Rivers people should quickly hasten up. And the INEC should help us conduct an election so that this thing can be done rectified.
All right.
But definitely, since they're contesting it, it will be going through the court process to Supreme Court perhaps before it is decided finally.
All right, Mr. Chinwo, we'll take it back to Mr. Nwobodo just in a moment, but let's take you to Port Harcourt. What is happening now at the government house where the Victor Okojumbo-led House of Assembly, that's Victor Okojumbo, led House of Assembly, screening members of a caretaker committee in the 23 local government area just a day after the governor dissolved the other council after the expiration of their tenure. So that's what is going on. We've seen some of the lists. At some point, we'll be showing you what the list looks like. I know that in Obiakpo, for instance, Chijoke Ihunwo is on that list as the chairman of, caretaker chairman of Obiakpo, I think, local government area, several others as well. So this is going on right now in Rivers State, the government house where the House is seated, led by Victor Okojumbo, where the screening of the House, the Caretaker Committee of the 23 local government chairman is ongoing. And let me bring it back to you, Mr. On this particular one, Ms. Anwobodo, when it comes to, there was a court in January, I think, January 21 or so, Justice James Omotosho had recognized Martin Amewule Group when they nullified the fact that, look, 4 people cannot sit and pass 800 billion naira appropriation bill. I brought that to the fore to ask you what happens to that decision of court when all of that happened, given what we're dealing with today.
Sorry, I didn't get that clearly.
Okay, I was referring you, Mr. Amo, but I was referring you back to the issue of the January order by Justice James Omotosho that recognized Martin Amewule as a speaker and then said that, look, the 800 billion naira appropriation bill that was passed by the here-led House at that time will be nullified. I'm asking, as a lawyer, that's a federal high court decision. What happens to that decision as it stands now? We know that in 11 prayers sought by the Martin Amewule Group that has been appealed, that was not even mentioned at all.
You are mixing, first and foremost, you are mixing the facts. You know, the Omotosho's case is different from the case brought by Okojaja, for which Martin Amewule appealed to the Court of Appeal. Now there is a subsisting judgment of the Federal High Court delivered by Justice Omotosho, which recognized Martin Amewule as the authentic speaker, and that judgment is still subsisting. Now you are asking me if what happens, what is the situation with respect to the 800 billion naira budget passed?
I'm very deliberate with what I'm asking. What was said was that Martin Amewule is the speaker, so that budget should be represented to him. I'm not talking about the budget. I'm talking about the subsisting decision of court that you just posited, because I know in the prayer sought, in the appeal, that was not even referenced. It was the reference.
Which appeal now? Which appeal
the
now?
The appeal that will be heard tomorrow. There were 11 prayers. There were 11 prayers.
So the way the court works, a man who is successful in a judgment does not need to appeal against his judgment. Omotosho's case is not the case being appealed against before the Court of Appeal Division in Port Harcourt. Now, the judgment that is being appealed against is the judgment that issued an order restraining Martin Amewule from acting as the speaker. And then the second one is the judgment nullifying the amendment made by the Martin Amewule-led assembly. So Martin Amewule cannot be appealing against the judgment of the Federal High Court that is in his favor. It is for those who lost the judgment to appeal against it. What Martin has done is that he is challenging the decision of the court of the
which is I know what I'm saying, which is why I'm asking what happens to that judgment now, given what we're not looking at it broadly.
Yes, the judgment is subsisting. It empowers Martin Amewule to continue to act. That's what we're saying. Martin Amewule is empowered to continue to act. And now when you mix it vis-a-vis with the constitution of the constitution, it is not my duty to say which court has the position actually or not. But the truth of the matter is that between the Federal High Court and the State High Court, it is the Federal High Court that has jurisdiction to determine whether the tenure of a House of Assembly has elapsed. So in all honesty, it is the judgment of Justice Omotosho that should be given preference to. Not a judgment that of the High Court that has no jurisdiction to make such
so you can see why I brought it in, so that we remember that there is another court judgment. That's why I brought it, so that you can speak to it, not because I'm mixing. I just wanted us to look at the entire case together.
Exactly, because it is the Federal High Court judgment that subsists.
Let's get the last word from Mr. Chinwo. Mr. Chinwo, your last thought as we begin to wind down on this particular issue.
Well, it didn't matter much, but let me say correct it. I'm Dr. Chinwo. When we struggle and end these things, we should reattack to it. The last word, one of state's sister media asked me, how do we get out of this situation in River State? I wish I can appeal to the FCT minister. We all know that it's at the center of this. It's not whether the law or politics and all that, but we're going to the point of one person has to take a decision that River State should move on. And like I said, I still say again, having served as local government chairman, chief of staff of River State, governor, minister, two-time minister, I think it's time to begin to think for once as statesman. And if that is done, I have peace in River State. And unfortunately, for the House of Assembly members, they are taking a decision without listening to their political godfather, which are taking them out of the constitutional protection. But I think with the intervention of we came in a positive light, in the interest of the states, these things can be solved. But as long as politics is put as number one, 2027, who controls, then we are unfortunately going to be running on like this. And that is not good for the River State at all.
All right, thank you so much.
And for the judiciary too.
All right. Chukwuma Chinwa, legal practitioner, as well as Achinike Williams-Wobodo, legal practitioner and public affairs analyst. Gentlemen, we thank you both, and we hope that River State will have peace. Thank you for coming on the program.
Thank you.
Thank you. Thank you for having me.
Well, we will now shift gears to the issue that has to do with the aviation sector. But we'll take this quick break. We'll come back. We'll start a conversation. Join us again.